recognize that we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing.
In regards to the next hearing date, how about October 30th at 10 a.m.? These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys.
The alleged assassin of conservative activist Charlie Kirk has appeared virtually before a Utah court as his defense gears up for a high-stakes battle against the death penalty. 22-year-old Tyler Robinson, charged with aggravated murder in the fatal September 10th shooting of Charlie Kirk at Utah Valley University, made his latest appearance online on Monday. The judge has now set October 30th as the next date for an in-person hearing, one that will be open to the public. Robinson faces 7 serious charges, including aggravated murder, obstruction of justice, felony discharge of a firearm, witness tampering, and committing a violent crime in the presence of a child. Prosecutors have indicated they are actively pursuing the death penalty in this case. The Utah County Commission has appointed Kathryn Nester, a former federal public defender with over 3 decades of legal experience, to represent Robinson. Nester has made it clear the defense does not intend to waive a preliminary hearing, stressing that discovery has not yet begun.
We recognize that we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in. I do recognize we're going to be getting that first batch in 5 days, but it's my understanding from our meeting today that there is massive amounts of digital that is going to be coming, and until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelims. So we're asking today that we put that decision off, and maybe we could check in 30 to 60 days and just kind of let the court know where we're at and how much we're looking at and how much time we may need to set a preliminary hearing. Also, as far as a detention hearing, we are not asking the court to address that issue at this time. Under the statute, the issue is going to come down to the question of whether there's substantial evidence, which right now we're just not in a position at all to be able to even argue to the court. So we are probably going to ask that the court delay that decision possibly until the time of the prelim. But if it's sooner, we will ask the court for a hearing. But at this time, we are not asking the court to make any decisions on that matter.
Thank you, counsel. In regards to the next hearing date, how about October 30th at 10 a.m.?
That works for the state, Your Honor. Thank you.
All right.
That's fine for the defense, Your Honor.
All right. Now, as we're at the beginning, anything further from counsel from either side?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. In regards to the next hearing, counsel, on that October 30th date at 10 a.m., it's the court's intent that it be in person if it be the wish of counsel for the defense for Mr. Robinson to be present.
It is, Your Honor. Thank you.
Thank you.
Prosecutors told the court they are still identifying multiple witnesses and sifting through what they described as voluminous evidence. The defense agreed, saying it was obvious the case remains incomplete at this stage. The court emphasized that once witnesses are identified, they must be properly notified and abide by the order. Both sides have now been given several weeks to prepare before the October 30th hearing.
There are a number of witnesses that have yet to be identified that will likely be used in the state's case. This occurred in front of 2,000 to 3,000 students at Utah Valley University. So we're in the process of identifying those witnesses. And so those individuals are presently unknown right now. So we're looking for a little clarification from the court. And I suppose we're not going to make any arguments today, but there may be some follow-up pleadings that we may need to file.
Thank you. Ms. Nester, did you want to be heard about that issue?
No, Your Honor, we would defer to whatever the court wants to advise them on that matter. I mean, I think it's fairly obvious that we don't know who all the witnesses are in this case yet. I think it's just important that if anyone is identified, that they have information about this order. So I think other than that, we wouldn't weigh in on any other matter.
Thank you. Well, thank you for that question. That's an important one. The court will rule that as the witnesses become known to each side, that information is conveyed to abide by this order. Obviously, there are potentially many witnesses, and so it's not the expectation that you would be able to do that up front, but as they become known, I would ask that you would inform them of this.